Can I welcome our next witness, the Director of Public Prosecutions. Just for the record, could you perhaps introduce yourself?
Keir Starmer, Director of Public Prosecutions. Thank you.
Could I just at this stage remind colleagues of the previous comment I made about straying outside the remit of this committee, despite what's going on outside? Mr. Andy Slaughter.
Six questions away, Chair, but I'll persevere. Mr. Starmer, Clause 12 of the bill, which was a surprise to some of us when it arrived, allows the Lord Chancellor to apply a means and a merits test, possibly other tests as well, to the provision of legal advice on arrest. Now, the Minister, we understand, has said that there are no plans to use this, but the fact is it will be in the bill if passed, if enacted. Do you have any concerns about Clause 12 and possible uses of it?
I obviously have an overall concern to ensure that the requirements of a fair trial are complied with, and they stretch back to the point of arrest. But I think as to the operation of Clause 12, I think that probably is something better put to the MOJ or the Legal Services Commission. My concern is there should be fairness in the proceedings, and that whatever is necessary should be put in place to that effect.
But do you, obviously, what is of concern to us, and it may be something you want to comment on or not, is that you will have situations going back to perhaps less enlightened times, pre-PACE, where individuals charged with perhaps relatively serious offences, or at least serious in consequence to them, will not have the benefit of legal advice on arrest. Is that isn't something that gives you concern?
I'd rather not get into the detail of that, because that is for others. But as a matter of principle, I am concerned that there should be full, fair trial rights afforded to all those in criminal proceedings, and that stretches back to the point of arrest. I do have that concern, but the detail, I think, is for other people.
Yeah, I think I'm going to ask you another point of principle, and then I'll leave it to my colleagues and perhaps come back if there's time. Part 1 of the bill deals with very significant scope changes to legal aid, and the impact assessment of the bill concedes that this is going to be detrimental to social cohesion and likely to increase crime. It's also going to mean that victims can, as you probably overheard at the end of the last session, could be being cross-examined by perpetrators without benefit of representation. Have you looked at the scope changes, and do you have any concerns from your point of view?
The honest answer to that is the extent to which I've looked at the provisions that don't directly impact on me or the CPS is limited, I'm afraid to say. I obviously listened to the questions and answers that were just given, and I know the general provisions and the general concerns of the debate that's going on, but I won't pretend that I've tried to delve into the detail of civil issues predominantly that don't directly affect me or the CPS, I'm afraid.
Yeah, one more question, if I may. There's quite a significant increase in out-of-court disposals in the bill, and we heard interesting evidence this morning that of a substantial variation between police areas as to the percentage. We heard that can vary between 33 and 66% of criminal offences being dealt with, and at least one Chief Constable saying that they thought that only 20% of offences should get into court. Do you have any concerns in relation to that, as to whether there may be more unfettered use of or a move away from judicial towards administrative determination?
I think that out-of-court disposals, if that's the right description, have an important part to play in criminal proceedings. They are invaluable for first-time offenders and for young offenders, and properly used, they are an important part of our criminal justice system. The difficulty, as I see it, is where they're used inconsistently, and there is obviously evidence in various reports of that. That is why I've long argued that they should be a part of our system, but there should be a coherent, consistent scheme and a step scheme for out-of-court disposals. And what I have in mind is a scheme that provides this level of disposal for this type of criminality, this disposal for the next level of criminality, etc., until there's a clear threshold for cases then going into court. My own preference is to set the threshold according to the criminal conduct, not according to the statistics. In other words, I don't seek to argue that X% ought to go into court or stay out of court. I would seek to argue that above a certain level of criminality, save in exceptional cases, the case ought to go to court. And the area of out-of-court disposals that I'm predominantly responsible for, which is conditional cautions, that is precisely the guidance I put in place, so that when it gets to a certain level of violence, the case becomes ineligible for an out-of-court disposal and must go to court. My own view is that the percentage, I don't think it's helpful to say 25% ought to go to court or shouldn't go to court. It's actually what's the threshold.
But we heard from the magistrate.
Sorry, Andy, will go further. Can I just say we have a very limited time in this session, and a number of people have indicated, so brevity, both in questions and answers, would be helpful. Ben Wallace.
Today.
Thank you.
Can I just ask a very brief question? The previous witnesses in the Law Society put together an alternative funding package, saying that a lot of the measures in the bill would not be necessary because we could raise money elsewhere to find savings or fund it. The biggest chunk of their proposal, £79 million, was saying that the CPS, of which you're responsible for, should pay for all judge-directed acquittals and dropped prosecutions at court. Can you tell me what your view of that is? And if you did have to find £79 million, what you would have to do vis-à-vis your administration of justice?
Well, I quarrel with the previous. I didn't hear that, but I would quarrel with it. And I know that it's in their report. I've seen it in the figures. I mean, the problem with their analysis is that the number of cases that have failed that are attributable to the prosecution is X%. Within that are all cases where the witness doesn't turn up, the prosecution witness doesn't turn up. Now, we run quite extensive witness care units. We do our level best to get witnesses to court, but where they don't turn up, to then say the prosecution must pay the cost is, in our view, unfair and counter to the way in which criminal justice ought to be administered. I'm all for driving out inefficiencies in the criminal justice system and within our organisation. I don't think that particular proposal achieves that end. And all that will happen, because costs there are paid out of central funds at the moment, is moving it between one pot and another. Better to require me to improve performance across the board. And that is a challenge I take up, and that's what I'm endeavouring to do.
What is your total budget?
The precise figure, I don't know off the top of my head, but it's about 650
drop as a note then.
million.
650 approximately.
Yeah. I mean, we can give you a precise figure.
No, that's fine. That's great. Thank you.
Okay. Ellen Gibbon.
Thank you very much. The government is proposing to change the way bail operates and replace the long list of reasons that that magistrates and judges can use to remand people to prison with a no prospects test. I'm sure you have thought about how you're going to advise the courts. Could you tell us how you plan to advise them on these issues and what you think the impact of this might be?
Well, I mean, I understand the rationale behind this provision. When it was first suggested, we had a number of concerns because the purpose of the bail regime is to prevent offending, prevent interference with witnesses, and to ensure people attend at court. And the first two of those are important. And we were particularly concerned about situations such as domestic violence situations where it is important to sometimes use the bail provisions to deal with a situation. To some extent, I have to say, the way in which it's now presented has allayed the fears that we had in relation to that, because there are now provisions, as you will know, in relation to the likelihood of offences within essentially the domestic setting. So where we had a concern there, I have to say that that's broadly been dealt with. There are other concerns, such as the court having to, at the outset, go through a sort of mini-sentencing exercise to assess what sentence it might impose. But that's a concern that I frankly think we in the courts will rise to and meet. So some low-level remaining concerns, but nothing in principle.
So you think that, well, what do you think the impact will be on attendance at court if you think that's a low-level issue? And if you think that the level of non-attendance will increase, are you content for people to be tried in absentia?
Well, I think you can be arrested for breach of bail and brought to court, and therefore that ought to be the first option if somebody doesn't turn up, and I'd much prefer that to trial in absentia. But I think beyond that it's difficult. I haven't seen any evidence to suggest that this is going to lead to a number of people not attending at court.
Can one infer from that then that magistrates worrying about that and using remand to prison are using remand to prison with that concern unnecessarily at the moment?
No, I don't think that's necessarily right. I mean, the scheme of the Act as it is to deal with the three purposes I've suggested. Where it is low-level offending, unlikely realistically to have a custodial sentence, then in the vast majority of cases those people would be on bail under the current system in any event. So we're talking about very small numbers. A far greater concern to us was the issue of offending whilst on bail and in particular circumstances that I've described, and that has been mitigated by the bill.
Can I ask you...
Alan, I just move on, because a lot of people indicated they want to speak. Robert Buckland.
Thank you very much. Mr Starmer, you dealt with the question of the costs element. I just want you to clarify for me. In fact, there is a provision already, and it's been around for many years, for wasted costs to be paid where there's been improper or negligent or unreasonable behaviour on the part of the prosecution. That's been around for years. That's
been around for years. It is exercised by judges on occasions where they think that our behaviour in particular has fallen below the standard required.
Yeah, thank you. Can I just move on to the part of the bill that I know you've been paying close attention to, and in particular Clause 54, the duty to give reasons for to explain the effect of sentence. It may not be apparent to every member of the committee, but the CPS does have a role, and it does exercise this role very diligently, I know, in writing to victims of crime to inform them about the outcome of cases, and in particularly serious cases there will be even meetings with victims of crime to discuss with them any concerns they may have. What is your view about the potential impact of new clause 174? Do you think it will make the job of caseworkers and CPS lawyers easier in putting together letters and explaining sentences to victims of crime?
Yes, I do, and we welcome it. I think anything that clarifies the process in court and simplifies it so that people can understand it is to be welcomed. And it seems to me that if the steps that are set out are gone through by the court, it makes it much easier for those in court and those that have to be informed afterwards to know what's gone on.
Thank you.
Okay. Kate Green, and if time allows, I'll come back for Ellen.
I'd like to ask about the government's proposed new offence in relation to knife crime. As a prosecutor, have you seen the need for this new offence to be created? This is with an offence of threatening with an offensive weapon or an article with a blade or point and creating a risk of serious physical.
Clause 113. The position, so far as I'm concerned, is as follows. The conduct that is created as an offence has long been criminal conduct, and we haven't experienced difficulties in bringing prosecutions for that conduct. So in a sense, nothing is added by the creation of an offence which covers existing criminal conduct. So far as the penalty is concerned, both the guidelines, sentencing guidelines, and in fact the case law have suggested that the ranges set out in the bill are right for these sorts of offences, and therefore the bill to some extent is reflecting what is already sentencing practice.
But this will be a mandatory sentence now. Do you have any concerns about that?
Well, there are think it's mandatory, but with some opportunity to take into account particular circumstances, and the circumstances are not dissimilar, in fact, to the circumstances that the sentencing guidelines and the courts have already suggested ought to be taken into account. I mean, there's a rigidity here that there wasn't in the sentencing guidelines. But I don't think there's any evidence to suggest that there was a problem with bringing charges in relation to this conduct, or actually that there was a problem in the application of the guidelines as they were. No doubt this will clarify the position, but I'm not sure there was a solid evidential base.
So, in fact, this new clause adds very little to what was already there, if indeed anything.
Well, I've not seen anything to suggest that there was a problem in either the conduct or the sentencing in this particular area.
Thank you.
We have a few minutes left, Ellen. Are you going to continue?
Thank you. Yes, I'd like to go back to the issue of out-of-court disposals. Yes. You said you were concerned about inconsistency in use by different police forces. Do you think that the reduction in the involvement of the CPS will increase that inconsistency?
Well, not necessarily. I mean, if we look at cases, it allows us to try to inject some consistency, and one of the things we've done is to make sure that all of our out-of-court disposals are put on a website quarter by quarter for each of our areas, so people can see whether we are being consistent. I think it's really agreeing with the police the approach and the thresholds that will bring the consistency. I'm not in favour of saying that only the CPS can bring consistency and the police themselves can't. We have to work with the police to bring that consistency. But it makes sense where the police can charge an individual to give them power to suspend that charging decision, which is effectively what it is, and allow them to conditionally caution.
So what do you think the appropriate instrument for agreeing that with the police might be?
But as I understand it, there's further work to be done on the overall scheme for out-of-court disposals. That's not within this bill. We intend to play our part in that. What is required here is a coherent framework. This is not critical of the police or anybody else. The framework we've got is one that everybody's inherited because it's been a piecemeal development. That was understandable. What we now need is a scheme that is much more consistent and coherent. But I don't think this bill's intended to achieve that. I think that's a separate piece of work.
Okay, you have 1 minute, Andy.
We're promised a new clause on the law of self-defence and residential burglary in the autumn. Do you feel a need for either a change or a clarification in the law on that, or do you think it's sufficiently clear at the moment?
My own view is that there is no need for a change in the law. I have no difficulty with clarifying a perfectly good law.
Order. Again, that brings us to the end of this question time. Thank you very much for coming along. I'm sure it's been a busy day for you.
Thank you.